And I got the mic on now. The Secretary of State's office was going to do a presentation, but we didn't get that noticed, and there was some communication between myself and the secretary. Secretary would like us to go to the archives because a lot of the things that happen in the Secretary of State's office happen at the archives. And so we will try to arrange that. Next week, I don't think is a good one to do it, since I think a few people are intending on going down to Washington next week. And so we'll probably try to arrange that for the week after on our regular day. It will be a noticed meeting. There will be a public and a non-public portion of that meeting, because some of the areas over in the Secretary of State's archives building contain information that cannot be released to the general public without violating various different things. So people will be invited to come along. I imagine we'll be in the reference room or whatever they call it over there for the public portion. But we'll make those arrangements. But again, there will be a non-public portion of that meeting, the way it looks right now, where you are actually taken to the various areas that deal with vital records and other things that are non-public records. So, any questions on that, either from the committee or from the audience? All right. That being said, our first bill, it must be SB 11. And we have somebody to introduce it. So
thank you, Senator Gray.
Yourself.
Thank you very much. I'm Senator Bill Gannon from the heart of the wine country in Sandown. We'll leave the other 12 towns. I'll mention them later. SB 11, I'll just read you 3 sentences, then I'll talk to you. SB 11 will ensure that New Hampshire's electoral college vote apportionment is the most representative of the will of the people. By aligning the electoral votes with the results in each congressional district, the bill encourages voter participation and ensures that the voice of each and every Granite Stater is most accurately reflected in choosing our president. SB 11 is a step towards more representative democracy, will encourage presidential candidates to be engaged with our voters, and continue our proud tradition of transparent, free, and fair elections here in the Granite State. This has come, so the idea is, it's very simple. If you win the state, you get 2 electoral votes, and then each congressional district will get, whoever wins that district will get the vote. It has happened several times in New Hampshire history. In 2000, in the Gore v. Bush election, it was a 2-vote margin of victory. Had the vote went to Gore in the 2nd congressional district, as it would have been by their vote, it would have been a 1 vote. So it gets very, very important. It may seem like it's just an exercise in political science, but it is not. It's very hands-on. In 2016, Trump would have gotten another vote. So the problem is, the idea is we just want to most represent the vote of the people as close to it as possible. In 2016, and since then, I did hear from people who said, geez, had we been a close election, we wouldn't have got our vote, our voice isn't heard. So again, we want everyone's voice to be heard. People have come to me over the years, not in huge numbers. It's not a bill like bail reform or something that you're going to see tangible results immediately. It may or may never take, it may never have an impact, or it might have an impact down in the future. But again, we want the voice of the people to be heard. We want a presidential in this last election. President Trump did not turn out here at the end because he didn't see any possible votes for him. So we want that, had it been that Congressional District 1 would have been represented, and he possibly could have won that one. If there was a vote there, he may have come out and heard us. We want our state to remain first in the nation by being more attentive to the detail and the wishes of the people. We're going to attract those presidentials. This will help keep our first in the nation. I think it's a simple bill, but again, we won't know, how important it will be. It'll depend on how close the elections are. But it could be, again, there was a 2-vote margin in 2000, and it could play a part. So again, we'd like New Hampshire to remain the most engaged state. We reflect the people's votes. We run great elections, and we want the people to realize that when they speak on something and they vote on something, this will give their vote more meaning so they don't feel that it's being overlooked. Thank you very much, Senator Gray.
Questions from the committee? Senator Perkins Coker.
Thank you, Chairman, and thank you, Senator, for being here to present this.
Sure.
So you've mentioned a couple different motivations for this bill. One is to make sure that every vote is counted, and another is more political, to make sure that sounds like President Trump would have gotten another electoral college vote. So is the motivation to make sure we're protecting our voters, or is it more political?
It's protecting our voter, because again, I want in the 2000 election, Gore would have picked up that vote had it been important. I want it to reflect you. I want the people in each half of the state to feel that their vote isn't being overlooked. Where, again, in 16, the vote of the people of CD1 wasn't taken into consideration as close as it could have been. So this is bringing the vote down closer to the people, and it would have helped Gore in 2000. I want it to reflect the will of the people as close as we can. This will do that. It could help either party. So I look at it as a bipartisan bill.
Thank you. Follow up, if I may, Chair.
Absolutely.
And we've heard a rumor that there will be a bill on congressional redistricting this year. How does this interact with that?
It doesn't interact with it at all. I know that some people are trying to do an Article 5 convention of state bill. I know it's been filed. I think Senator Innes filed it. I'm not a co-signer. I have concerns about that bill for different reasons that I'm afraid of a runaway convention. So I have fears. I like the idea of term limits. I'd like term limits in New Hampshire. I think we should have them on our Senate seats. The House is a different beast with 400 people, but I think ours would not be a bad idea to have a 10 or 12-year limit, as I think would be the same in Washington. I think that would benefit, keep the flow of ideas fresh and new.
Thank you. Thank you, Chair.
Senator Lang.
Thank you, Senator Gannon, for taking my question. So my question is, so under the current model, my understanding is a winner take all.
It's a winner take all.
Winner take
all
all.
four.
You win the state, you win everything.
Sure.
And why wouldn't we go to a overall proportional representation for the whole state versus by district? Could you explain that?
So people, I would like it to be smaller so that people are like, we'll just say CD1, that's my side. So I did have people come after 16, and even they talked about it at the convention with me on the floor, the Republican convention this summer. And they brought up, I did file this bill like 8 or 10 years ago, or a very similar bill. And so a lot of people have talked to me and said, our votes don't count. I have so many people who, Senator Gray is very familiar with, dozens and hundreds of people who are concerned with our elections being fair and honest. This makes people say, okay, I voted CD1, our side. It's a closer, if we do, rather than statewide, if we had a congressional district, it makes it much more representative. The people's vote in this, our side of the state, may be different than those in CD2. So if the majority of our side wants a particular candidate, I'd like them to get that vote. Whereas right now it would be lost. You could lose, the people could overwhelmingly on my side, but not hit the total. They could be 60, 70% and still not get the candidate that chose.
So again, but why wouldn't we go to a statewide proportional rather than by congressional district?
We could do it that way. That would be another way of doing it. This is the way they do it in Maine and Nevada. So I looked to how they're doing their current system. It seems to work. Some people don't like it. Some people do, just like every other bill and form of government. So I followed their models. It seems to work well for them. And I thought it was a good system to copy.
Last question. So last question. So again, your goal in the bill is in a 60-40 race where the majority, somebody gets 60%, somebody gets 40%, is to give voice to that 40%?
Is to give voice to, if it was on my side, the congressional side, the 60 or 55% that chose either the Democrat or the Republican, they'll be heard. And then you'll still get your 2 votes for winning the main part of the state. And then you'll pick up 1 because just numerically you'll have had to have won 1. So it'd be 3-1 sometimes. And those people aren't being overlooked. Just makes the system more responsive to the voters.
Thank you.
I had a question.
Sure.
Certainly during the primary, we have a good representation of the candidates here in New Hampshire. But after the final candidate is chosen, we have seen that the lack of the candidates coming back to New Hampshire and Maine and some of the other areas around. What do you say to someone who says this will further dilute that vote and make it even more difficult for us to get a candidate up here into New Hampshire during the final portion of the election?
So one problem is we do have certainly the numbers in, say, California, they have 60 or whatever electoral votes they have. So a big state is more enticing to a presidential candidate. But had President Trump thought that one vote was in play, he would have been here. He had no thoughts that he could carry the state, so he wasn't going to come here. If it was by congressional district, you can bet your bottom dollar he would have been somewhere on CD1 the last 2 or 3 weeks of the campaign. If that one electoral vote was in play. I looked at the maps 3 or 4 weeks. They had so many scenarios that it was 2 or 3 points one way or the other. Our one vote would have made a difference to a presidential candidate this last election and in future ones. So I think it attracts presidential candidates to come at the end.
Senator
We're a small
Perkins-Coker.
state.
Yeah, thank you, Chairman. Thank you, Senator. You know, as we all think through how this works, I mean, isn't the truest representation of our voters' will to be all electoral college votes at large? I mean, as you're making your point, you're sort of making the point that, you know, some votes would count more than others because they'd be in a more concentrated district. So do you really think this is the best way to sort of represent our state at large?
I do.
By changing it? Thank you.
Okay, seeing no other questions, thank you, Senator.
Thank you very much.
The next
All
on the list here signed up is Liz. Come on up.
Thank you, Senator Gray. Good to see you again, and thank you for to all the senators for letting me speak. My name is Liz Tentarelli. I'm president of the Nonpartisan League of Women Voters of New Hampshire. And both personally and on behalf of the league, I urge the committee to oppose this bill. I realize we can't talk about other bills or other possibilities here, so I'm not going to talk about the National Popular Vote Compact, but I snuck that in, didn't I? If the goal is to make voters feel that their voice is heard, paying attention to the popular vote without an electoral college would, of course, do that. It's very possible, and research has shown this, that if enough states use this kind of proportional voting, that it's much more likely for the final result to go to not the Electoral College decision, but to the House of Representatives for a decision. In other words, it's more likely to have a tie in the Electoral College when there are a number of states that would have proportional voting. That would be especially true if there were a strong third-party candidate. We haven't had that in a few years, but we're all old enough here to remember when we did have some, when there actually were electoral votes won by a third-party candidate. Maybe that's what you want. You want the final decision to go to the House of Representatives in Washington. Maybe you don't. I don't like that idea. It would be the newly elected House who would cast a vote, one vote per state. There's no clear definition of how that state would decide how to cast that vote. So that's another problem. I admit that we have only 4 electoral votes, and just changing us probably wouldn't make much of a difference. Maine and Nebraska are the only 2 states that do this currently. And in the last election, Nebraska has 5 electoral votes, and one of them went to the candidate who did not win the state. And the opposite candidate got 1 vote in Maine, where they have 4 votes. So 3 went to one candidate and 1 went to the other. They happened to balance out this time. You know, I don't know where New Hampshire would be. Senator Gannon spoke to the possibility that doing this kind of proportional voting would encourage the 2 main candidates, after they've been chosen, to spend more time in our state in order to get a vote. That's what Nebraska thought too. It didn't happen. And, you know, who knows why it didn't happen. But they found that, you know, each candidate sent a vice president for 1 visit. No, I'm sorry. Vice President Walz, as a candidate, visited Nebraska twice. Vance visited once. The major candidates still said, we know where this state is going, so we're not going to go there. So I'm not sure that the sponsors' intentions will be met by this. There certainly might be other ways where we could become a more active swing state once again, as we remember, but I'm not sure this is it. Thank you very much for this opportunity, and I'll give you my written testimony that has a few more facts in it.
Thank you. Questions from senators? Seeing none, thank you very much.
Thank you.
On the second sheet, I do have a Ken Barnes, I believe, that wants to testify.
That would be me, Senator Gray. Thank you very much. And thank you, Senator Gray and members of the committee, for allowing me to testify. My name is Ken Barnes. I live in Katuquik, New Hampshire. I speak in opposition to this bill for several reasons. One, the Senator Gannon gave roughly 2 main reasons for his bill, and the first is that he said it would give more voice to the average New Hampshire voter. But this way of doing it by congressional districts is purely an arbitrary way to give more votes to people that live in CD1 versus CD2. You could divide it by county, and you know, you could divide it by city. You could divide it a lot of ways. And as Liz Tantarelli said, just doing away with the Electoral College and allowing the voice of all people to determine the number of votes that the presidential candidate gets, that is the most democratic way to do it. And it would meet Senator Gannon's goal of having the voices of the people actually be reflected in the presidential vote. And in addition, I think that this way of doing it by congressional district could be manipulated and skewed, made non-objective by political maneuvering in gerrymandering, in determining the congressional districts. You know, every 10 years, we redraw the district lines, and there's no, Senator Gannon didn't give any reason why the people in CD1's voices should be more lifted up from the minority than people in Portsmouth or another place. And the political maneuvering would just skew the results in a way that would just make things more political and less reflective of the voice of the average New Hampshire resident. Thank you.
Questions from the senators? Seeing none, thank you very much.
Thank you.
Is there anyone that did not sign up that wishes to speak at this time? Mr. Say, you've changed your mind. All right.
Thank you, Mr. Chairman and members of the committee. I'm Alvin C., representative of Merrimack County District 26, which is Loudoun and 7 other towns. And I speak in opposition to this bill. The Electoral College was intended to prevent large population states from being able to overwhelm all the smaller population states in the selection for the president. This bill dilutes that function for a small state such as New Hampshire. If California and New York were to do this, maybe it might be something worth reconsidering in New Hampshire, but for now, I'm opposed to this. Thank you.
Thank
take
you.
any questions.
Questions from senators? Seeing none, On the sign-in sheet, there was one more person who supports, one more person who opposes, and on the online, there was 2 in support and 71 opposed. And with that, we will close the public hearing and open the next one in just a minute.
We'll go ahead and open up the public hearing on Senate Bill 16 and recognize Senator Gray, the prime sponsor.
Thank you, sir. My name is James Gray. I represent Senate District 6, which starts up in Alton and Gilmanton, goes down Route 11 to Rochester. Senate Bill 16 requires the municipalities to post a copy of the election result form that they send to the Secretary of State up on their website. Right now, the question in the last election came up, how do I find out about all the write-ins? Okay. Secretary of State's website does not list all of the write-ins. The sheet that is provided by the town clerks and the city clerks does contain that information. And simply by posting a copy of that, we can take care of the situation, and the people will see who was voted for. And it's important to several of my constituents, so we have the bill in front of us. Question has come up as to whether we could just take a picture. I personally don't have any problem with taking a picture of that and being able to post that. Another issue was the rule right now says we'll post it online and post it in 2 other places. Apparently some towns only post in 1 place. Again, I think we can get over those hurdles. Certainly the library in Rochester is a wonderful place to post things and sometimes gets a more diverse population coming through than post them on bulletin board. So again, it's not, something that, if there are objections that we have to worry too much about them. Certainly I know that if I had my all-in-one printer, scanner, fax machine, whatever, there I could accomplish this real quick. But again, how we offer exemptions or get the Secretary of State to send it back if not, or whatever, certainly it can all be worked out. Thank you.
Questions for Senator Gray? Senator Perkins Cook.
Thank you, Chair. I suspect this is a question for the Secretary of State's office if they're planning to say something. But the language of the bill is fairly general. So where it says any social media accounts utilized by the municipality, I certainly support the intent. I just want to make sure we're setting towns up to be successful. So is enforcement of this intended to be sort of encouragement or?
Certainly the words may include or something could be inserted in there to take care of your comment. But again, the thing is to get those votes out, to be able to, right now, the constituent who asked me about this, I said, well, you have 2 choices. You can either go to the town and ask for those, and if you were in a county where you're looking for the votes in sometimes going to that town is a long way to go, or you can go to the Secretary of State's office. Certainly, either one of those would be able to provide it to you under the right to know, because they would have copies of it there. So,
Hello?
Yeah, follow up if I may, Chair. And then just one clarification. We got a letter from the city of Nashua asking not to require a third location, but I do not read your bill to require posting in a third location. Do you agree?
Well, the third location, the way I read that,
Is the website.
was the website.
Got it.
And then posting in 2 locations. And that's why I mentioned the other, you know,
May include.
right. And when I drafted the bill, somehow it never got in there. But we tell people to post these things all the time, but we don't tell them how long they have to post them. And certainly, you know, I don't know why OLS took it out, but I'll ask them at some point. You know, posting it for 30 days or 60 days is more than sufficient. And maybe there is a part in the statute that I'm not thinking of right now that does say that, you know, some of these postings don't have to be there forever. But
Okay. Thank you, Chair. Thank you.
Further questions? Representative,
Thank you.
Senator, sorry.
Senator now.
Sorry.
All right, I'll answer. I guess I answered to it, so it's my problem, right?
you know, I don't know about you, but I even answered a "Hey, you."
Thank you, Senator, for taking my question. You know, I can see I can see the where you're getting at with this, and someone who likes information and likes it in a timely manner, I certainly can appreciate that. I'm thinking about my district. You know, I've got a town with 6 voters in it. I've got another town with which does not have a town clerk or doesn't have a town office, doesn't have a town website. How would this impose a burden on those towns that don't? And I can think of at least 2 my towns out of 50 that don't have a town website. You know, one of the unintended consequences I'm seeing with this perhaps could be requiring a municipality to develop something that they don't already have. And how could we address that concern with these towns?
And that's the reason for the sheet that they have to send to the Secretary of State. Okay, the return of votes that you send to the Secretary of State lists the people, and then it lists all the write-ins. Okay, so it's something that they are already doing. In some of the smaller towns, I'd have to look at your towns to see if they report individually or they are combined with somebody else to do certain reporting. Secretary's deputy, you know, might be able to come up and answer that, or we can get that information offline. But we're not trying to impose a burden. And that's why, again, I don't have a problem. They have to fill out the sheet that has to go over to Concord, you know, taking a picture of it, you know, scanning it. However you get that copy of it is fine with me, and posting it in a place where people can see it. And in most cases, you know, that is a city or a town website, and on the bulletin board in the town offices.
Anything else? So I have one question. So you'd be willing to amend, because the way I read it, again, the concern about the number of locations, the way the law reads, it says it shall be posted in 2 places where you normally post, and the website and the social media site, which means 4 potential postings of the data. And you're willing to work around that to deal with
Well,
issues such
willing-
as Senator
Willing
Roachford.
to work with the committee to do what will pass.
Thank you very much. Anything else? That's it. Next up is Margaret Burns.
Good morning. Thank you, members of the committee. I'm Margaret Burns, the Executive Director of the New Hampshire Municipal Association. I'm here this morning simply to express the same concerns that have already been raised about the number of places that a municipality would be required to post the election return forms. I want to echo the concerns of the City of Nashua, as well as the concerns raised by Senator Roachford about municipalities who do not have a website. We respect the additional effort for additional transparency and are happy to work with the committee on an amended version of the bill that would address the concerns of the municipalities and not put an overly heavy burden on municipalities with respect to places that posting is required.
Thank you. Questions? Seeing none, thank you very much. Next up is Autumn.
Good morning. For the record, my name is Autumn Rashid Goodwin. I'm the program coordinator for Open Democracy. Today, I'm just providing a brief testimony on behalf of our executive director, Olivia Zink, who could not be here today. What it says here is we need to reduce the influence of big money in politics and increase the voices of average citizen. This bill provides transparency and accountability. Open Democracy supports requiring municipalities to post a copy of election return forms on their websites and in public locations. Within the Special Committee on Voter Confidence Recommendations on Expanding Voter Education, the report said that local municipalities should use a common website template for election information recommended by the Secretary of State's office. In a survey done in 2022 of town and city websites, only 98 towns posted the election results, leaving voters in 127 without any results. New Hampshire voters have the right to know the election results, and the legislation should act quickly to increase transparency.
Questions? Seeing none, thank you. Did committee members have questions for the Secretary of State? We ask them to come up if not. Doesn't look like it, so you're off the hook. Is there anybody else who wishes to speak on Senate Bill 16? Seeing none, we'll close the hearing on Senate Bill 16. We will move on to Senate Bill 45.
Thank you, sir. Hey, watch out.
Senator Gray, please introduce your bill.
Thank you. My name is James Gray. I represent Senate District 6, which starts up in Alton and Gilmanton, comes down Route 11 to Rochester. This bill, Senate Bill 45, is meant to open a conversation about political signs. That if you read the statute the way it is right now, I believe that probably between 85% or more of the signs that are put up are actually illegal, that they are posted in the right-of-ways. And although if you are posting in a state right-of-way and you have permission of the abutter, the way the language is the owner of the land over which the right-of-way passes, because in New Hampshire's history, a lot of times the roads were built on people's lands and there was a right-of-way given to the state, but the underlying owner way back was the individual. So that complicates the situation. But right now, there are many, if you go to intersections, especially the larger intersections in a lot of the towns, you see sign after sign after sign at the intersection and then dotted along the highway. Certainly, if I were to guess that there's no owner's permission. I was approached by one of the committee chairman in the House and says, well, he says, anybody that posts a sign on the front, in front of my house, I rip it down. Well, I don't think that's illegal either, because, they don't have permission to do anything in that right of way, whether it's take somebody else's sign down or not. So this bill, if nothing else, is meant to have a conversation and let us, come online and say, well, what are we going to do or what are we not going to do about the signs? There's communities out there, Rochester in one, that says you can't have a sign in the right of way. And I went and told him, I says, well, state law says if I have, right of way that goes in front of my property, that I can do it. And so they had to back off at least a little bit on state-owned right of ways, but did not allow any other right of ways. Some of the complaints that I've seen were people saying, well, gee, this allows, putting signs on, public property. Well, hey, we're not talking about, down at town hall or city hall. We're not talking about the library. We're talking about the right of way. But, there are certainly implications. And I think that's why a certain person may be here to my left and rear about those issues. But again, let's start the conversation. Let's figure out what we want to do with those signs, and so that more of them are legal than illegal, and go from there.
Questions for Senator Gray? Senator Long.
Thank you, Mr. Chairman. Thank you for your testimony. With respect to the 10 feet from property line, is that just on public property, or is that also on private property?
Well, right, the way that's worded, or intent of the wording, is that if I am at a location where the road is hundreds of feet away from the actual property boundary, that I want them up by their property and not somewhere else. The Attorney General's office has given me some other words that talk to that. And so, they would like to see that reworded just a little bit. But again, I'm trying to start the conversation. I'm trying to get us to a place where we can agree or disagree. Various communities across the state do different things with signs. So let's at least start talking about it.
Follow up for me?
Hello?
Thank you. Yeah, my concern is in the city of Manchester, a lot of landlords will put up signs. That's fine. And the tenants will put up opposite signs in their windows. So and sometimes that's more than 10 feet away. So I just wanted to be assured that we're having that conversation.
If they are putting the signs up in their window and their lease does not preclude it, that is their curtilage, their domicile, their whatever. So it is not that 10 feet is when I'm putting it in the right of way, not when I'm putting it on, my own property or whatever. Because there are sign ordinances in various towns that could restrict political signs, but there's also Supreme Court rulings out there that says that you can't restrict a political sign more than you restrict some other sign, or restrict, so, and again, if Henry comes up, you can ask him all those questions that you'd like to ask him, and, I'll sit and listen along with you.
Very good. Thank you.
Follow-up questions? So last question, I just want to make sure I understand section C. So section C in the bill, it talks about the 10 feet. The intent is that it has to be within 10 feet of somebody's property line.
Route 202, as it goes through Rochester near my house, the right of way there is probably 150 or 200 feet wide.
Right.
Okay. And so, if I'm going to put up a sign because I own, part of that, I want that sign up by my property line. I don't want it down near the road where it could interfere with traffic. I don't want it, they do more mowing down at the lower part of that than they do at the upper part. I mean, whatever the safety requirements are and everything else still has to be, but, I don't want that sign down on the road, when my property line is 100 feet away. And that was the intent of it. And again, I'm not hard over on any of this. But what we've got right now is being violated every day of every election.
Thank you. Anything else? Thank you, Senator Gray. Ken Barnes?
Hello again, I'm Ken Barnes from Kentucky, New Hampshire. And I really appreciate Senator Gray's initiative to take something that's not clear in the law and probably being violated all the time, whether it is or it isn't. If the rules aren't clear, then the public doesn't know what rules it's supposed to follow. So trying to clarify that is wonderful, and I applaud that. I really do. I'm not sure it's clear in here what that it gets at what Senator Gray has in mind. If I understood what Senator Gray just said towards the very end about he wants it not to be right down on the road, wants it further back, but this 4C says the advertising, it may be placed on the right of way if it's not more than 10 feet from the property line. So that means it has to be within 10 feet of the property line. I assume, Senator Gray, you're talking about the property line that's where the street is, right? Or not the property line, that's the homeowner before the state right of way. I think that definition of what property line you're talking about matters, but I think that you've got not a double negative here, but a positive and a negative. So it says, 4 says political advertising may be placed within the right of way as long as it's not more than 10 feet. And if I heard Senator Gray correctly, he was trying to get it further away from the street. That is more than 10 feet rather than not more than 10 feet. That's all. I just wanted to be clear and what the rule is and to understand what he's talking about. And just one other thing, I agree with Senator Gray's point that if I put it in the window of my house, that's protected First Amendment free speech, New Hampshire Constitution right to place it there. But isn't it also your First Amendment right to place it, a sign like right next to your house on the outside, since you own that property? And then as it gets closer and closer to the street, to the right of way, where's the line where the state can preclude it without violating free speech rights? So I don't oppose this. I just wanted to clarify. Any questions?
Yep, just a clarifying statement. So that section 4 is only dealing with signs placed in state right-of-ways, right? And so that 10 feet, it just says that in a state right-of-way, you have to be at least no more than 10 feet from the property line of the edge of the state right-of-way.
The street edge
That's not the way I read it.
or the back
It
edge?
means the back edge, the private property line.
The back edge, okay, so that does.
I just meant it to your point of I can put it on my own property. That's a true statement. This bill doesn't deal with that.
Yeah. Okay, so perhaps C could be written a little more clearly so that it's obvious you're talking about the property line between the state right-of-way and the property owner rather than the property line between the state right-of-way and the street.
Any questions for Ken? Seeing none. Thank you. Oh, I'm sorry.
That's okay, Chairman. No, I just want to ask a clarifying question. Would you believe that when a right-of-way is made, the private property line stays in place and the right-of-way just kind of goes over it? So it could be helpful to just clarify this language slightly, given the number of questions in committee, if you agree.
Yeah, and I'm not sure that that's even accurate, that the property, once the state has the right-of-way, I don't know that I, as the property owner that the state took it from, took ownership from, I don't know that I have any rights. Or if you want to, I don't know if you intend to create any rights in the property owner once the state has already taken the land.
Thank you.
Thank
No further questions. Margaret?
Good morning again. Thank you. Margaret Burns with the New Hampshire Municipal Association. I wish to just express some concerns about the legislation, some of which have already been raised, and we are happy to work with the prime sponsor and the committee as appropriate to try to make the bill potentially more workable. I can certainly agree with Senator Gray that the statute probably does need some clarifying. It is not the most crystal clear state statute that I have ever read. There are also more fundamental, overarching, potential constitutional issues with treating political signs differently from other types of signs, which I'm sure someone else in this room is going to speak to, and I do not need to do so. With respect to current municipal policies and ordinances regarding placement of signs on the right-of-way, currently it would be within the municipality's authority to make those decisions about whether signs are placed within the right of way. And this bill sort of retains that municipal authority. I view it as sort of an opt-out provision for municipal authority as opposed to an opt-in. So under paragraph 5, the default position would be that political advertising is allowed unless the municipality takes a proactive action through ordinance or bylaw or the like to prohibit the posting of signs. So our position would always be that the authority to make that decision should rest with the municipality. That being said, again, it does preserve some municipal authority with respect to public rights of way. And I do not see this bill as changing in any way the municipal authority to regulate signage on other municipal properties. So we're talking about, the library lawn, the town hall lawn. It does not touch that provision in the beginning of the statute. It simply deals with rights of way. So happy to work in any way with the committee as appropriate on this bill. Thank you very much.
Questions for Margaret? Seeing none, thank you, Margaret.
Thank you.
Henry, come on up.
Good morning. My name is Henry Clementovich. I'm the Deputy Legal Director of the ACLU of New Hampshire. So we are here to oppose the bill, but in fairness to Senator Gray, we also oppose the underlying statute that it is amending. I see a few problems with this scheme. So number one has been alluded to is that this bill treats political advertising different from other signs. So Senator Long, to your point about the tenants and the landlords putting up signs, even if they weren't in the windows, even if they were along the right of way, if it wasn't within the narrowly defined definition of political advertisement, those signs would not be impacted by the scheme at all. And so what this bill is basically doing is targeting just the signs that say vote for or vote against someone. It doesn't, impact at all a giant sign that says like blowout sale at Ocean State job lots or stand up for workers or Black Lives Matter or whatever the sign may be if it's not political advertising. So in the Town of Reed case, the U.S. Supreme Court has said that that's what's called a content-based, viewpoint-neutral discrimination, which has to survive strict scrutiny because in order to know whether the sign is impacted by the statute or the ordinance, you have to read the sign to know whether it's political advertising. And so for that to be the case, it has to survive strict scrutiny. And so the question is, what type of state interest and tailoring mechanism is there to justify treating political advertising different from other advertising? So that's one of the concerns that we have, is that this, and it's not limited to the bill, it's the statute itself, but is that it singles out political advertising from other types of signs. And, I'm not an expert on roadways safety other than as a driver, but I'm not sure that the state could prove that a sign saying, vote for Senator Gray is going to be more distracting to a motorist than the one that says stand up for workers' rights. So I'm not sure there's that justification. Number two, as Senator Perkins Quokka alluded to, when we're talking about a state or town-owned right-of-way, the underlying fee, and this is like taking me back to my first year in law school, so you're going to have to forgive me, but the underlying fee remains with the homeowner. So they, we were taught that property is like the quiver of arrows, and that the person who owns the fee has all the rights except for the ones that they give away. So they own the property except for whatever rights there are for the right of way that have been given to the city or town, which is probably like maintenance, having people drive over the roadway. But like if, there were an oil deposit found underneath the road or something, it would still stay with the homeowner. By the same token, from my perspective, because the private citizen is owning the underlying fee, it's their property subject just to this limited right of way for the purpose of traveling in a car. They still have the same First Amendment rights there. It should be treated or considered their home, just like the rest of their property is, because they own it the same way. They just have given away one particular right. So like, what if you have a barn there, within 10 feet of the right of way or whatever it is, you still have the same rights to paint whatever sign you want on that. It's, the U.S. Supreme Court has said that the First Amendment rights for signs and that type of thing are strongest in the home. So I just think that given, as Senator Gray said, New Hampshire's unique history, which I know basically nothing about, about the way that roads have developed over private land. We're talking about really regulating signs on people's private property where there just happens to be a state-owned right-of-way. If the state wanted to go around buying sign easements from everyone, or a town wanted to, that would be a different scenario, I think, because you would no longer have the right to put up the sign because you would have given that away in the marketplace. A related tailoring issue, as I talked about, is if the real concern is preventing, distracted drivers from being on the side of the, driving past these signs and getting distracted from it, then it wouldn't really matter whether it was a public right of way or not. The question would be, is it within 10 feet of a road? And so I think that's another thing that the committee could look at is, what exactly are we trying to accomplish? If it's really about protecting drivers from too many signs, it should have to do with the proximity to the road and not like the question of ownership, which would probably require a survey to prove anyway. So those are, I think, largely our concerns. My own, our view is that like political signs are just a fact of life in New Hampshire. I know that they're annoying to look at, but like if we want to get rid of political signs, we, should stop having elections. Otherwise, it's just something we've all got to deal with. I'm not advocating for that. I'm pro elections. I'm pro the signs. I don't know that they matter. I know that they're annoying, but they're constitutionally protected speech. So I'm happy to take any questions, which I'll answer as well I can.
Questions?
Thank you.
Anybody else who wishes to speak on Senate Bill 45? Seeing none, I'll close the public hearing on Senate Bill 49, turn the gavel over to Senator Gray. Now I'm going to go take his place.
And just to catch us up a little bit, I did have the sheets on SB 16. There was online, one in support, one in opposed. On 45, there were 2 in support, 1 opposed. And we haven't gotten to 43 yet, so we'll do that when we get there. All right, the prime sponsor.
Thank you, Senator Gray. Thank you, members of the committee. I'm Senator Tim Lang from District 2, covering the Lakes region all the way north up to Campton and Thornton, 93. I always go back to my New Jersey roots where I was born. I say I have exit 20 to exit 29 on the east side of the highway. So this bill before you just seeks to clarify an issue that's come up around electioneering in the polling place. As you know, New Hampshire has a law under RSA 659-43 that prohibits the wearing of clothing, political attire inside the polling area. Back in 2018, on June 14th of 2018, U.S. Supreme Court issued a ruling on a Minnesota law that did the same thing. It was classified as a political apparel ban in Minnesota, and they held that Minnesota's political apparel ban violates free speech and the First Amendment clause in the Constitution. The way they delineated that is prior to that, there was a case called Burson that went to the Supreme Court, and that had to deal with the creation of corridors to give voters clear and free access to the polling place without being harassed by us politicians. And so in Burson, the Supreme Court found that that was legal. That the ability to create a corridor or allow voters to be unimpeded to be able to get to the polling place was allowed. And they use a delineator of active campaigning, interfering and campaigning with the voter. And so they withheld that was okay. But in the Minnesota case, they ruled that it was passive campaigning to be wearing a shirt or a hat or a button or a pin while you were in the act of voting, and that didn't meet the criteria of Burson, and therefore overruled the Minnesota law. So what this bill seeks to do is just strike the word or articles of clothing from the distribution piece to allow, again, if a person's walking in with a Kamala Harris shirt or a Trump shirt into the polling place and they're in the act of voting, they're walking in, they're in line to get the check into the voter checklist, to get their ballot, to fill in their ballot, and then to drop it in and walk out, that is not electioneering. and therefore not subject to this law. However, again, I'm a moderator 15 years for my town. The way we've always viewed it is, again, we use active campaigning. If you're going to sit in the polling place and talk for 20 minutes, I'm going to ask you to leave if you're wearing a campaign shirt. I'm going to ask you to step outside. That is, you're no longer in the act of voting. You've either completed it or you're waiting for it. I'd urge you to go through the process. What we don't want is what happened in Dover, where a woman was wearing a campaign shirt and the moderator told them they had to remove it. And so she did right there in the polling place, just took her shirt right off and hung out there in the polling place while she finished her balloting. So again, I just want to bring this into alignment with the First Amendment ruling of the Supreme Court, strike the ruling of just the idea of just wearing clothing is active electioneering and therefore subject to our law. I will say there will need to be an amendment because after talking to the Attorney General, there's a place further back in the statute that also needs to be amended to deal with this issue. And so if the committee is willing to entertain an amendment, I'll get that language from the Attorney General office and where that is and exactly how it's to be struck and work with committee members to clean this up. That's it. That's the whole pitch.
Questions from the committee? Okay, seeing none. Tim?
Thank you. Ken Barnes again.
Actually, it was the representative.
Oh,
Not Ken, but Tim. You're on the list. You're on the list. We'll
That's
get
okay.
there.
My hearing's not perfect either. Actually, I'm having a hearing test on Friday, so maybe. So my name is Timothy Horgan. I'm a state rep from Durham, and luckily it was in Dover, the next town over, rather than Durham, where that unfortunate incident happened. And I think understand the free speech concerns. So I'm usually all in favor. I'm usually a big supporter of free speech, but actually the polling place is not really a venue for speech. You're supposed to do that outside the electioneering limit, and you can wear as many articles of clothing as you want, wear as many pins, hand out as many handbills out there, and you're not supposed to do in the polling place. The polling place is sort of a secure and neutral location where you fill out your ballot and hand it in, and they count it, and hopefully they count it correctly. I know there's a lot of concern about that nationwide, so that's not really what's supposed to happen in the polling place. You've already the citizen. You're supposed to be trying to persuade your fellow citizens who to vote for outside that perimeter. So that's I hate to make too many exceptions to free speech, but I think that's an appropriate one. And also, of course, my moderator is a little bit stricter than apparently Senator Lang is. I think I was even told once I had to take off my little official. I think it was probably this jacket, and while standing at the polling place, and the moderator made me take off the pin because it said Timothy Horgan is a state rep, so he thought that was like an example of electioneering. So I think notwithstanding the Minnesota court case, which I may have to review before deciding what to do about this bill if and when it makes it across the wall to the House. I think the law as it's written is appropriate, and we can usually, even though sometimes there's a breakdown, but usually we can rely on the voters and the election officials to behave appropriate, to be appropriate and not make too many unnecessary trouble. But there probably are extreme cases where an article of clothing could be distracting. I'll also say, of course, sometimes it's hard to tell, whether what clothing is electioneering or not. So if you wear a bright red hat that says, doesn't necessarily say "Make America Great," and even "Making America Great" isn't, doesn't say "Make Trump Great." It just says "Make America." So there's a lot of gray areas, and we probably don't want to have too many disputes between election officials and voters. But I think we should leave the law. We should leave the law the way it is, even though I've unintentionally violated by wearing my button, or in that one case, my name tag into the polling place. So that's why I feel like. So I just feel like I understand the impulse behind this bill, but I think we better to ITL it, and so thanks.
Just an FYI,
Yeah.
the interpretation that I've heard from the Secretary of State's office
Yeah.
about you wearing your legislative badge, since it doesn't say vote for
Yes.
or elect or anything, that it is not electioneering. But certainly the Secretary of State and the Secretary, the Attorney General are the ones that interpret that statute.
Yes,
for us.
I mean, understand that, and I was probably mostly just humoring the moderator, who's an old friend of mine, and not to make more trouble, and probably the print on my badge is pretty small, so most people who already either don't know who I am or already know what I look like. So
Questions from the senators? Seeing none,
Well,
thank
thanks.
you very much. And now we'll get Ken.
Thank you, Senator Gray. I'm sorry my hearing aid misheard you. I'm Ken
So, right,
Burns.
we'll deal with it.
It's a pleasure getting old. What can I say? So I agree with what the representative just said about leaving the bill the same, leaving the statute the same. The clothing, I understand the impulse that it's coming from it, but Senator Lang, as said, as the moderator, you would consider it being in the act of voting if they were there for 15 minutes, but if not, if longer than that, they were electioneering. But nothing like that kind of a restriction or clarification appears in the statute. And in fact, the statute only talks about the election clothing is prohibited within the no electioneering corridor outside the polling place. So the way I read that, it seemed like people could, if your amendment taking out articles of clothing is adopted, people can stand in the no electioneering corridor outside the polling place, and people do stand there for more than 15 minutes. They stand there for half the day or whatever, and they can be a human billboard. They can, have an enormous sign that basically says vote for somebody. And Senator Gray mentioned it doesn't say vote for somebody, but if it says President Kamala Harris, it's pretty clear that the person is asking somebody to vote for Kamala Harris for president. So again, this sounds like it's not doing what Senator Lang intended, that when I go in to vote, I can wear what I want, but it says that people can stand out there in the corridor all day being a human billboard. So I urge you to oppose that. Thank you.
Questions from senators? Seeing none, thank you very much. Linda?
Morning. Thank you for letting me appear here. My name is Linda Calloway, and I'm the town moderator of New Durham. And I have a statement I'd like to read regarding the removal of the articles of clothing from the electioneering items and activity. Committee members, there are two basic precepts people seemingly conflict in this proposal. Electioneering is about influence inside or outside a polling place. Speech inside a polling place is your vote. As town moderator, I consider voting to be a civic duty and not a partisan activity. This is the whole purpose of the secrecy of the ballot and the insistence on nonpartisan behavior in all respects in the polling place. The electioneering-free zone, both inside and outside while entering or exiting from the polling place, is to allow people to vote unencumbered by unwanted opinions of their fellow voters, except as prescribed by law. This is a day for people to vote without undue influence of others. Most voters respect and are appreciative of this concept, and I have been thanked by some voters for enforcing it. I feel that allowing voters to wear quote-unquote signs or slogans on their clothing which advocate for or against a particular candidate, party, or issue is unduly corrosive to the atmosphere within the polling place in particular. There is a reason only the legally mandated signs are allowed to be posted within the polling place. As a matter of clarification, would the removal of articles of clothing as an electioneering activity at the polls also apply to volunteers who are working at the polls? Thank you for your attention, and if anyone has any questions.
Questions from senators? Seeing none, thank you very much. Is there anyone who did not sign up that wants to speak? Deputy Secretary.
Thank you, Mr. Chairman and members of the committee. Good to see everyone. I'm looking forward to when you're able to come to the Archives Building for a tour and explaining all about what we do in our office. My name is Erin Hennessy, and I am the Deputy Secretary of State. I had a very brief conversation with Senator Lang before the hearing started. I understand his intent on the legislation, and as Ken pointed out, as written, this would just remove the ability for somebody handing out buttons to also hand them out in the electioneering zone entering the building, but just clothing. So right now, as written, it would allow somebody who's electioneering outside the polling place to go and hand out hats and sweatshirts and T-shirts in any area of the outside the polling location. We discussed that perhaps his intent would be to change the definition in 652 16H, which defines electioneering, but as the moderator from New Durham pointed out, if you change the definition in electioneering, you're also changing what would the use of electioneering in all the other parts of the statute which prohibit electioneering in the polling place by a poll worker. So I just want to caution, I know you said that there is an amendment forthcoming. I just want to caution if changing the definition also changes a lot of the other areas of the statute. Happy to take questions.
I'll consider the amendments.
Any other questions from senators? All right, thank you very much.
Thank you.
Okay. The sign up online, there was 0 in support, 5 opposed, and everyone who was on the sheet here spoke, so there's no others there. That concludes this hearing. And is there any need to go into an executive session? Seeing none, then we are adjourned.
I don't know, I'm gonna find out maybe.